Hello, everyone, and welcome to this webinar hosted by Security Compass. My name is Eleanor Lee, Product Marketing Manager at Security Compass, and your host for today's webinar. Before we get started, I'd like to address a couple of housekeeping items. It would be good for you to know. First, a recording of this webinar will be available after today's event. You will receive an email with a link to the recording. And also, secondly, we encourage everyone to raise questions. You can submit your questions into the chat, and I will collect and we'll address them at the end of the presentation. We'll also, we hold webinars that deep dive into a range of cybersecurity, privacy, compliance, and software risk topics monthly. If you have attended any of our past webinars, welcome back. For those of you who may not be aware of us until today, Security Compass started out with a team of very experienced penetration testers in 2004 and has since evolved to become a security software company that offers professional advisory services, training, and SD Elements, a first of its kind expert platform that translates security standards into actionable tasks to improve your security posture. Our mission is to help customers manage cybersecurity risk without slowing down their business. For today's webinar, we're going to take a close look at the impacts of CCPA. I'm pleased to have here with me Judy Zhu, a member of our research team here at Security Compass, specializing in privacy, risk, and compliance. Judy is an experienced security consultant and researcher, having implemented privacy programs, compliance initiatives, and led security assessments across a variety of Canadian and international businesses. Judy is a certified information privacy professional, and I'm so grateful to have Judy here with me. Judy, thank you for coming back, for being here with me again.
Thank you, Eleanor. Hello and welcome, everyone. In this webinar, we will discuss some practical steps for CCPA towards implementing a CCPA-compliant privacy. We'll discuss the key CCPA requirements and rules for businesses, the consumer rights under the CCPA, and some privacy safeguards and steps you can take to implement a CCPA-compliant website or application. We'll then compare the CCPA with the EU GDPR and discuss what we can expect to see in the new. Sorry, everyone, just dealing with some audio issues. I hope everyone can hear me better. All right, we'll dive into the first section. I wanted to give you some background into the CCPA. The California Consumer Privacy Act is the first major consumer privacy law enacted at the US state level. It's been in effect since January. So the CCPA has been in effect since January 1st, 2020, and its purpose is to enhance consumer privacy rights and privacy notice requirements for residents in the state of California. The CCPA is applicable to any business or entity that collects consumer personal information, does business in the state of California, and satisfies one of the following conditions, that being revenues greater than $25 million per year, the business processes the personal information of 50,000 or more consumers, or the business earns more than half of its annual revenue from selling personal information. There's 5 main consumer rights under the CCPA, that being the right to notice, the right to access data, the right to request deletion, the right to opt out of sale of information, and the right to receive service on equal terms. Penalties issued under the CCPA can be up to $2,500 per violation if it is not remedied within 30 days. Penalties can be up to $7,500 per intentional privacy violation. The California Attorney General and is permitted to bring civil action and issue fines under the CCPA. CCPA also provides for consumer lawsuits, statutory damages, and the private right to action. The consent requirements in the CCPA are much lighter than that of EU's GDPR, and there is no explicit opt-in consent requirement for collecting personal information except for children's data under a certain age. The CCPA strengthens control and privacy rights for California consumers and hopefully all US consumers. It sets the stage for the next steps of a comprehensive US federal privacy law, and we'll talk a little bit more about the similarities and differences between the CCPA and GDPR and what we can expect to see from US privacy towards the end of this presentation. I want to talk about how the CCPA came to be and the private activists behind it that championed this legislation. So a brief history of privacy rights in the state of California on your right-hand side. In 1972, California voters amended the California Constitution to include the inalienable right of privacy for all people. In 2018, the CCPA was passed as law, and since January 1st, 2020, it's been enforceable and in effect. So Alistair McTaggart was a Bay Area real estate developer and a data privacy activist. He organized the CCPA ballot initiative process with his organization, Californians for Consumer Privacy, and funded this ballot initiative himself. He spent close to $3.5 million lobbying lawmakers and negotiating the contents of the bill. The CCPA is notable because it places regulations and restrictions on some of the largest tech companies in the world that are based in California. But of course, there was obvious significant pushback and counter lobbying from these tech firms. The final version of the CCPA is much lighter than the original, but Alistair McTaggart, this privacy advocate, he's currently working on the next iteration of California privacy legislation called CCPA 2.0. So California certainly now has stronger privacy protections and regulation in place compared to many other states. And the EU's GDPR obviously served as a natural inspiration. And we'll talk about what this means for a federal privacy law towards the end. So this chart discusses if your business is in scope for CCPA compliance. You're in scope for compliance if your business collects, processes, sells, or otherwise shares personal information, and some additional criteria. A business under the CCPA is a for-profit legal entity doing business in California that collects personal information regarding California residents. So the scope of compliance applies to companies that sell goods and services to California residents, even if they're not physically located in the state of California. It also applies and protects California consumers that are temporarily out of state, whether traveling, etc. Its application beyond the state of California and beyond even US borders significantly expands the impact of the legislation. So there's just a reminder of those three criteria for compliance. So to fall within the scope of the CCPA, businesses must also meet at least one of the additional three criteria, having 25 million or more in gross annual revenue, processing the personal data of 50,000 or more records, or if the business earns more than half of its annual revenue from selling consumer personal information. There's some definitions I'm going to go over under the CCPA. First of all, as for what constitutes personal information, the term is broadly defined as information that identifies, relates to, describes, is capable of being associated with, or could be reasonably linked directly or indirectly with a particular California resident or household. This definition of personal information includes personal identifiers such as names, address, IP address, email, account name, social security number, and other unique identifiers. Commercial information, including records of property, product, services, and other consumer habits or tendencies. Internet and electronic network activity information, including browsing history, search history, and information regarding a consumer's interaction with a website. So this may include cookies, advertisements, etc. Geolocation data and biometric information are also covered. A business under the CCPA, again, it's an organization that operates for profit and collects or processes the personal information of California residents. A consumer is a natural person who is a California resident and includes every individual who is in the state for temporary or transitory purposes as well. So this includes all California residents who are California residents for tax purposes, whether they're traveling or inside the state. So this definition is quite broad. Moving on to household. So under the CCPA, a household is defined as the collective of individuals, like a family or occupants at a residential address. A household and consumer are treated to be the same when it comes to personal information under the CCPA. Consumer privacy rights. The CCPA affords various privacy rights to California consumers in order for them to exercise control over their personal information. These rights include the right to notice, the right to access personal information, the right to request deletion, the right to opt out of sale, and the right to receive service on equal terms when exercising your consumer rights. An opt-out of sale per the CCPA, a consumer shall have the right at any time to direct a business that sells their personal information to third parties to stop transferring their personal information. Talk a little bit more about this right and what it means in detail in the next section. And finally, the definition for sale of personal information. This often causes confusion, so just wanted to spend a little bit more time around what sale of personal information means. So I think one of the biggest challenges when implementing the CCPA is determining what constitutes a sale of personal information for your business. So the CCPA has a very broad definition of sale, meaning selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating a consumer's personal information by the business to another business or third party for monetary or other valuable consideration. So it's noted that valuable consideration at the end makes this very confusing and broad. So this definition of sale covers all disclosures of personal information for valuable consideration. This goes beyond the traditional exchange of money for further use of information. Activities such as tracking cookies, sharing personal information with affiliates and marketing partners, and data providers could still constitute as a sale. However, not all third-party disclosures do constitute a sale under the CCPA. It's important to review your contracts and service provider agreements to see if there's any restrictions on further use of that personal data once it's exchanged. You should consult your legal teams on specific cases of sale of personal information as it relates to your business. So in this section, we'll go over the key requirements and business impacts of the CCPA. There's three main categories under which we can group the CCPA's requirements: consumer privacy rights, data security, and service providers. The consumer privacy rights, there's 5 of the main rights, which we've mentioned already, and I'll go into detail in the next section. So they're on the right-hand side, just to remind you. So this means that California consumers have the right to exercise these privacy rights, and businesses must also notify consumers of their rights upfront. The CCPA also calls for reasonable data security measures to be put in place. Organizations complying with the CCPA should assess data security risks based on the context of their business and take steps to minimize threats related to the confidentiality, integrity, and availability of personal information. And finally, the requirement that relates to service providers includes third-party vendor management and the ability for consumers to opt out of the sale of their personal information. This involves updating your third-party contracts and vendor agreements to include data privacy protections, as well as being able to accommodate those consumer privacy requests, such as opting out of the sale or requesting to delete their data, making sure that these processes follow through to your third parties and partners as well. There's various business and operational impact involved with implementing a strong privacy program and complying with the CCPA. Top business impacts can be summarized here in 4 categories, and I'll just go over them briefly. CCPA expands the scope of compliance and who's covered. So the expanded scope includes businesses beyond the state of California and protects consumers. It protects California residents, whether they're in the state or not. Accountability and compliance. CCPA requires stronger accountability for businesses by placing greater control of personal information in the hands of consumers. Businesses are obliged to fulfill consumer privacy requests and protect their data. The CCPA also requires greater transparency into a company's privacy practices, including providing clear privacy policies, purposes for processing, and informing consumers of their rights and allowing users to easily opt out of sale. There's also higher risk associated with implementing CCPA. There's increased financial, operational, reputational, and legal risks for businesses that don't comply. Fines can be up to $2,500 per violation, and consumers can pursue the right to private action. So in the section, we'll dig a little deeper into the 5 main consumer privacy rights under the CCPA: the right to notice, the right to access data, the right to request deletion, the right to opt out of sale of personal information, and finally, the right to receive service on equal terms. We'll go over what they are, what they mean for businesses and consumers, and how to exercise your privacy rights. So the first right is consumers' right to notice. Privacy, you may be familiar with privacy policy or privacy notice, which refers to the document that's provided by a company to its data users describing the type of personal information that the company collects about them, how that data will be used, with whom that data is shared, and how that data is protected. The CCPA expects that every company that collects data from Californians provides a privacy notice stating the privacy policies of the company upfront. It should be given at or before the point of collection of data and be easily understood and accessible by users. The next is the right to access data. This refers to an individual's right to request and receive their personal information from a business. It means that an individual can ask a business to confirm whether it holds any of their personal information, to disclose the categories of personal information it has collected about the consumer, and to provide a copy of the personal information that the business has on file. Requests to access data must be verified by the business, and organizations must provide 2 or more methods for submitting access requests, such as a phone number, a website contact page, and an email address, or a combination of these. The requested information should be provided in a portable and ideally electronic format. And in most cases, the access request must be responded to within 45 days and the information delivered free of charge. Every consumer can request to access their data twice in a 12-month period. The right to request deletion means an individual can request that a business delete their personal information it has collected about them. So similar to the right to access previously, requests must be verified and responded to within 45 days. The business must also request that service providers and third parties delete the applicable personal information in the deletion request. However, it should be noted that an organization can refuse to comply with a consumer deletion request for a number of exceptions. For example, to comply with a legal or contractual obligation to detect data security incidents, debug and identify functionality errors, and so on. The right to opt out of sale is a key feature of the CCPA, and it refers to the ability of an individual to direct a business to not sell any of their personal information. Consumers must be able to opt out of the sale of their personal information through a link on the business's homepage. Remember this complicated definition for sale of personal information. I won't repeat it here, but it's on the bottom. So once a consumer has opted out of the sale, the business cannot request additional consent to sell their personal information again for another 12 months. There's also additional restrictions for the sale of children's data, such that explicit opt-in consent is required in that case. So opt-in consent is required when you're selling children's data. And explicit parental opt-in consent is required when you're selling data of anyone under the age of 13. And the last consumer right we'll cover is the right to receive service on equal terms. This is also referred to as the right to non-discrimination and means that an individual can't be discriminated against for exercising their consumer rights under the CCPA, such as when opting out of sale or requesting to delete their personal information. Examples of discriminatory activities under the CCPA might include denying goods or services, offering discounts to those that do not opt out, offering varying levels of service or quality. So any financial incentives offered should not be unjust, unreasonable, or contingent on the consumer opting into the sale of their data. So this is more of a passive right, meaning consumers cannot actually exercise it, but you must notify consumers of the right in your privacy policy and be transparent to disclose any discounts or financial incentives that might be contingent on someone's data. In this section, we'll look at some general privacy safeguards that can help you proactively comply with the CCPA. And following this, we'll go over some steps that will help you implement these consumer rights processes. So some general privacy safeguards, first of which is data mapping and creating a data inventory. So create a data map and inventory to understand where your data flows and resides. This makes it easier to classify your data, track the purposes for processing the data, and apply the proper protections to sensitive data. Data inventory should include the categories of personal information collected, the source of that information, how it was collected, how it will be used by the business, whether it will be shared or sold, where it is stored, and when it will be deleted, and whether any consumer requests have been associated with that information. Consent management. Track your consents, privacy preferences, and opt-out of sale requests through a consent management system. Make sure your purposes for processing personal information are updated and accurate. Compliant privacy policies. Be transparent in your privacy policies. Provide a privacy policy that is easy to read and informs the consumer of their rights. Give users increased control over their data through privacy preference features. The fourth is opt-out of sale link. If your business sells personal information, make sure to properly implement the opt-out of sale feature in a web page, including the back-end features that might trigger the consent management system and opt the user out right away. Communication channels. Much of the CCPA is all about consumer rights and allowing them to submit those requests and exercise those rights. So you should make it easy for consumers to submit their privacy requests, inquiries, and questions by providing multiple channels to receive and triage these consumer requests, such as request forms, contact pages, email addresses, and a toll-free number. So Now let's visit each of the consumer privacy rights in a bit more detail, and we'll discuss the steps businesses should take to be CCPA compliant. The first is the consumer's right to notice. This requires updating your privacy policy and informing consumers of their rights and what you're doing to protect their data. Make sure to provide a list of all the categories of personal information collected about the consumer. List out the business or commercial purposes that their information will be used for. Inform consumers of their privacy rights and how they might exercise those rights. If you intend to sell personal information, provide consumers with notice and provide a link titled "Do Not Sell My Personal Information" that allows consumers to opt out of sale on your homepage. And finally, provide a link to your privacy policy on your homepage, as well as all pages and points that may collect personal information. The second right is the right to access data. When responding to access requests, make sure to provide multiple channels for users to submit their requests for access, deletion, and exercise of other rights. All of these channels and ways to contact the privacy office should be outlined in your company's privacy policy. Be sure to verify the identity of the consumer that's making the request. And remember that one consumer can make up to 2 access requests every 12 months. Put in place the appropriate data security measures and make sure to deliver the data in a portable and ready-to-use format, and be able to provide the requested information free of charge and within 45 days. The third right is the right to request deletion, or the right to be forgotten. Here you'll need to verify the identity of the consumer making the request, depending on the sensitivity of the data that's being requested. If the consumer has a password protected account, this is one way to verify their identity. Implement appropriate security measures to detect fraudulent identity verification activity and prevent any unauthorized access to or deletion of personal information. And again, be sure to delete the personal information free of charge and within 45 days. And there's certain exceptions that apply. And the final right is the right to opt out of sale. If you sell personal information to third parties, consumers should have the choice to opt out of the sale. Identify the customer accounts that have currently opted in for the sale of their data and track their preferences in a consent management system. Update your website or application to include the "Do Not Sell My Personal Information" link, where consumers can exercise their right, and also include this link in your homepage and privacy policy. Once a customer clicks the "Do Not Sell My Personal Information" link, ensure the proper activities and workflow are triggered through the consent engine in the back end, so their preferences are updated as promptly as possible. So chances are you've already heard about the EU General Data Protection Regulation, the GDPR. Here we'll compare the CCPA to the GDPR. And if you've already implemented privacy protections for the GDPR, you'll likely be in a better place and ahead of the pack in terms of CCPA compliance. Let's compare. First, we'll look at some of the similarities. Both the GDPR and CCPA have broad regulatory scope and coverage. This includes businesses outside the EU for the GDPR and outside of California for CCPA. Both the GDPR and the CCPA protect any resident within their jurisdictions. This means if you are an EU or California resident abroad, you are still protected. So all businesses dealing with EU personal data or California consumer data are responsible for compliance anytime they interact with an individual's personal information. And finally, both the GDPR and CCPA grant individuals the rights to notice, access, deletion, and restriction of the processing of their personal information. There's several key differences in the way that GDPR and CCPA operate as well. For one, unlike the GDPR, which affects all EU personal data, the CCPA has set some additional requirements regarding size and scale of processing. The GDPR also generally requires opt-in consent for collecting and processing an individual's personal data, whereas the CCPA does not. In fact, the CCPA does not require opt-in consent at all, except for children's data. It only requires that consumers are notified of collection. Oh, and they have the right to opt out of sale, of course. Next, the GDPR requires businesses to give a 72-hour breach notification to regulators and data protection authorities in case of privacy breaches, whereas the CCPA does not currently mandate any breach notification requirements right now. And lastly, the GDPR needs businesses to explicitly ask individuals before sharing their information with third parties, whereas in the CCPA, businesses only need to notify the consumers before they share or sell data to a third party. So the CCPA is now the most comprehensive privacy law in the United States, but many other states have followed or will soon follow with their own state privacy legislation. The other two US states that have a comprehensive privacy law in place right now are Nevada and Maine, but there are up to 12 other states that have privacy bills introduced or in committee. In 2019, there was also a lot of talk of a US federal privacy law. This was driven by increased consumer attention to privacy issues, as well as the CCPA coming into effect and businesses preparing for that. So currently, there is still no comprehensive federal privacy law enforced in the US, but we'll go over two privacy laws that were introduced in the US Senate at the end of 2019. The first is the Consumer Online Privacy Rights Act, or COPRA. This was introduced by the Senate Democrats in November 2019. And on the other side of the aisle is the US Consumer Data Privacy Act of 2019, or the CDPA, introduced by the Republicans. So both of these federal privacy proposals include many of the same privacy protections, and they will both be enforced by the Federal Trade Commission, or FTC. So some of the similarities between both COPRA and CDPA include, similarly to the GDPR, both bills will require affirmative consent from individuals before processing sensitive information. There's requirements of transparent privacy policies, reasonable data security controls, and privacy impact assessments. Both proposals also provide individual rights to access, correction, and deletion of data. So the US has lagged behind Europe and some other developed nations in terms of privacy regulation and enforcement, but as privacy issues and data breaches continue to garner the attention of consumers and individuals all around the world, all eyes will be watching to see if a comprehensive privacy law can be passed in the US in 2020. That's all for today. I think Eleanor will have some words and we'll be happy to answer some questions for today.
Great. Thank you, Judy, for a very informative presentation on CCPA. Here at Security Compass, we understand that tracking changing regulatory standards and ensuring compliance with complex requirements is a challenge to even the most mature organizations. Our solution, SD Elements, translates complex standards such as the GDPR, CCPA, and NIST 800-53 into easy to understand development and IT tasks. It allows you to use an auditable and consistent approach across your software projects and helps you achieve compliance readiness with regulatory standards and internal policies. We also help organizations elevate the security knowledge of development teams with our e-learning solutions. In fact, in March, we will be releasing a new e-learning course on CCPA for software developers. So stay tuned for that. This course aims to introduce developers to the CCPA and its impact on their work. And this will help them to adopt CCPA compliance in their daily tasks and identify the risks of non-compliance at the very beginning of their projects. So at this point, we would like to open it up to questions. We do have a few questions from the audience. Let's start with this one. So question from the audience, would one breach of 1,000 users' personal information be about violation penalty of $2,500, or is that 2,500 multiplied by 1,000? So how is that determined, basically?
Yeah, this is a great question. So the penalty that's outlined in the CCPA is up to $2,500 per record. So in that example, it would be 2,500 1,000, so $2.5 million, which is a lot more significant. However, it's only been in effect since January 1st, 2020, so we haven't seen too much guidance or fines issued by the Attorney General yet. There is guidance that that $2,500 fine is for violations that haven't been remedied within 30 days. So once you're caught for your violation, you do have up to 30 days to prove that you're fixing the issue.
Great, thank you for that question, great one. For large enterprises, what would you say are the most challenging aspects of complying with the CCPA?
I think one of the biggest challenges with CCPA is identifying the scope of compliance. This whole concept of whether you're selling your data or not, this is very difficult to determine for some organizations. So really understanding your data, reviewing all your customer contracts, and identifying what information is actually being sold. And as well, another challenge, organizational challenge, would be implementing the back-end processes. So once you receive these consumer requests, what happens on the back end? How is it processed and tracked such that this information is accurate and these requests can be fulfilled within 45 days?
Great. Another question is, if a consumer opts out of sale of their information under CCPA, does that mean that businesses can't do any business with them anymore?
So the question here is if a consumer opts out of sale of their personal information, does that mean that you can't do business with them anymore? You can't interact with the consumer anymore? So that's not the case. So if a consumer opts out of the sale of their personal information, you can continue doing business with them as long as you no longer share or sell their personal information with third parties. So this is obviously a challenge if your business derives much of its income from selling personal data, but making sure that users have these options will really help you with compliance. So making it clear to customers what information you collect and sell, as well as providing privacy preferences and choices to what types of personal information they'd like to share or sell will really improve the user experience and increase their trust in your business.
Okay, and one final question before we conclude. Could you clarify if opt-in consent is required under the CCPA? Is it going to be a feature in the upcoming U.S. federal privacy law?
So opt-in, opt-out consent, I know that causes a lot of confusion for a lot of people, but generally speaking, the CCPA does not require opt-in consent, while the GDPR does require opt-in consent. So opt-in consent is not required under the CCPA, but you must provide notice before a consumer's data is collected. If you sell the personal information, they have they should have the option to opt out of that sale. So they should be able to restrict some of their processing. With the federal privacy laws that have been introduced, there is a feature in both of them for opt-in affirmative consent when processing sensitive data. So this is a feature in a lot of data protection regimes around the world. So it will be interesting to see if opt-in consent will be a feature in our federal privacy law.
Great. Thank you so much, Julie, for a very engaging presentation on CCPA. We hope that this has given everybody practical steps to take to implement CCPA-compliant privacy notices and web applications. Again, we will provide a link to the recording of this webinar via email. Do join us next month for another webinar. We will publish the topic very shortly. Please visit the resources page on our website at securitycompass.com for more information. Thank you, everybody. Have a wonderful rest of your day. Thank you for attending this webinar.